Hello, and welcome to this Centre Lunchtime webinar series. So I'm Andrew Thompson. I'm the Interim Director of the Rees Centre, and as I'm sure you're aware, the Rees Centre we focus on research and improvement of lives of children care using high quality evidence, and we hope to bring together research policy and practice to support better outcomes for children and families. And I'm really delighted to be welcoming Professor Karen Broadhurst today. And just to say before I introduce Karen, that this is the first in a series of three seminars. And this series explores how linked administrative data across family justice, welfare, health, education, and criminal justice, it has the potential to transform research in this field. So it's a very exciting area for us at Rees and for everyone in the field. Across the three sessions, speakers will show how cross-sector data can generate stronger evidence on systems, pathways and outcomes, reform policy practice and better support for children and families. We couldn't start with a better person to kick this series off. So Professor Karen Broadhurst is Professor at the School of Social Science at Lancaster University. She was awarded OBE 2026 for services to child and family justice, family justice research, and she was conferred to the fellowship with the Academy of Social Sciences in 2020. Karen is recognised nationally and internationally for high quality, high impact research that's catalysed measurable change in policy and practice, with a specific focus on women and children involved with children's social care and families courts. Karen's team, particularly at Lancaster, but elsewhere too, has produced the first estimate of women's repeat appearances in the family courts, catalysing major improvements in preventative services for mothers living apart from their children. She designed the Born Into Care series for the Norfolk Family Justice Observatory, and covering the scale of infant removals at birth and drawing attention to glaring of women's rights in the immediate postpartum period. Karen collaborates with colleagues in the US, Australia, in Europe, and in the UK, of course, to improve justice for families, with the most recent ESRC funded project focused on women caught through systems of family and criminal justice and equity for children. Karen has held numerous expert advisory roles, including for the Commission on Justice in Wales, President of the Family Division's Public Law Working Group, and the Independent Review of Children's Social Care. So Karen has agreed to talk for roughly 40 minutes, and then there'll be some time at the end for questions. So welcome, Karen.
Lovely, thank you, Ian. That was a lovely warm introduction. I'm just going to try and share my slides with you all, but I'm delighted to be here. Thank you very much to my Rees Centre colleagues, and it's great to see Bashar Al-Roo, who recently left us and we're still crying. Great to see you, Bashar. I think Teresa's online, and I've also seen Ellie. Lovely to see you from the observatory. I think Aoife might be here as well. Aoife, apologies if you're here in person. I'm not. I've had a last minute change of plans. Can you all see this?
Yes. Yes, we can.
Yes. Yeah. And can you all hear me clearly?
Yeah, perfect. Thanks.
Perfect. Okay. So I'm going to give you a talk in 4 parts. I haven't timed it. I'm not quite sure how long it'll run, but I'm sort of mindful I'm starting at 12:05. So the talk it's really designed. I'm not sure who's in the audience, but I'm trying to share with you some of the key things that I've learned over the years in terms of working with admin data. So I want to do that, and I want to kind of try and set the scene as well for the next 2 talks. So this talk is quite broad ranging, and it's also perhaps covering some things you might not expect on the subject of trust. So the talk's in 4 parts. The first part speaks directly to context, and I'm going to talk in a little bit of detail about this kind of questions of trust and legitimacy in the family justice system. And I'm sort of presuming people might not know too much about this, but it's kind of like important to kind of set the context before we think about the contribution of research. So the second part, I'm thinking about the implications of this particular context for family justice research. and why it's so important to have system-wide and population scale knowledge. And the third part of the talk, I'm going to talk about best practice in the use of admin data, again, drawing directly on my own experience. And then I'm going to give you a worked example from the Born into Care series, which is a series, as Ian said, we developed with the Nuffield Family Justice Observatory. Okay, so if I start with this sort of fundamental basic question, why does the family justice system require robust research evidence? It certainly does. It's lagging in relation to health and education. But there are also some very particular things about this system, which if you're doing research in this area and you're using these large-scale data sets, you need to think about really carefully. So obviously the first one is this is a system that makes highly consequential decisions for children and families. So, you know, we can remove children from their parents' care, we can change living arrangements. We need to know if and how the system is delivering better outcomes for children. Obviously, the Reece Centre has been very good at looking at some of those outcomes and permanency questions. So the first set of questions are really about effectiveness, impact. They're operational questions, they're effectiveness questions. But then there are also some really important questions in this space, which are legitimacy questions. And I think it's really important if you're thinking about the system as a whole, that you actually capture and think about, that I capture for you and think about these broader questions. What kind of a system is the family justice system? Can I just check that you can all hear me okay?
Yeah, 100%.
Yeah, good. Okay. Okay, so some of you may not be aware that there has been a kind of growth in what we call legitimacy questions. There's kind of, in fact, a sort of chorus of legitimacy questions about the family justice system. Some of these relate to the closed nature of the family courts, and some of them are broader legitimacy questions. So I'm going to talk, that's my starting point really, is to kind of almost sound a bit of a caution, but also really emphasize the importance of these other questions. So the family courts are unique in the UK because they're not open, a bit like the Court of Protection, they're not open to anybody going in. So they don't quite conform to what is a kind of long-standing common law and constitutional principle of open justice. So there's historically, if we look back over the years, there's a sense that the public need to be involved in justice and they need to observe justice and have access to justice to enable its legitimacy to be maintained. It's a bit different in family law because this principle of open justice is it's not abandoned, but it's qualified. And because the courts they're in a really tricky position, they need to they need to protect children, sort of first and foremost, protect families. And by putting that sort of at the centre, we do not allow the public and we do not allow media to have free range in these courts. So what that's done is create an ongoing public, legal and academic debate about whether the current balance, which is of some selective media reporting and some access, and the closed nature of the courts, whether that's okay. And this has led to some very fierce challenges, legitimacy challenges of the family courts. And many of you will have, heard critics, activist group talking about the secret family courts. So I'm not here to kind of align myself with this group or not against this group, but to tell you really that the concerns of of activist groups in particular who talk about secrecy in the family courts is that these courts are departing too far from a principle of open justice because proceedings are largely held in private with media reporting restrictions. And the idea is that secrecy is not benign, it's not straightforwardly protective, because what it does is it shields institutions from accountability. So closed proceedings can hide mistakes, they can hide unreliable practice, and they can hide poor professional conduct, as well as obviously containing good professional conduct. In a closed system, what this means is that avenues for challenge are insufficient. So the language of secrecy has huge currency now. You'll see very powerful lobbying and activist groups really challenging the courts around its closed or secret nature. So that's one, if you like, one type of legitimacy question. But if we go to my next slide, for the family courts, there are broader legitimacy questions that have been gathering pace. So I've just divided them into these 5 categories for you, but as I move on, you'll see why I'm saying this to you. But there are questions of procedural fairness, and researchers, certainly myself and Bashar, have begun asking such questions. So there are questions around, has the court followed the necessary steps to enable a fair process? And this overlaps with human rights issues, for example, in relation to Article 6 or Article 8. So has justice followed what it should do in order for parties to be on an even footing and for us to have a sense of a fair process? That's procedural fairness. There are lots of questions also, though, about substantive justice, which is this outcome justified? Should this child have been placed with kin? Should this child have been placed with adopters? And it's a question, substantive justice, it kind of overlaps with the point I'm making next. It's an issue for an individual case, but it's also a broader issue of the question per se. For example, is kinship a justified and positive permanency outcome? Is adoption, etc.? Okay, so it overlaps with these other legitimacy questions, which are really about system bias, and they relate to the gendered, class and race and disability questions. We could go on to discuss other aspects of exclusion. I'm just here listing these for you. So what we know in the family justice system and the child welfare inequalities group in particular, which originally led by Paul Bywater, but with contributions from people like Rick Hood, and then our own team, the work of Bashar here, that we know that there are the concentration of family court cases in the poorest communities. We know that that practice is stratified by race and also by class, and also people with disabilities are hugely affected. I couldn't go on to talk about immigration status. I could talk about sexual orientation, but we know that there are systemic biases that are there in the system. Now, these biases have also been given a, if you like, a further sort of development through post-colonial thought. And I think the family justice system, this is really important as well, because there's a fundamental questioning now of what we would see as Western individualized approaches to child protection. Our concepts of permanency, of child removal, of what constitutes a family, what constitutes substitute care, are now very strongly thrown into question through post-colonial thought. And there are some examples of fantastic writing, particularly from Indigenous writers in Australia and New Zealand, writing about this issue. In relation to the work that we've done at Lancaster and with colleagues at Rees, there are also now more questions about what are the social consequences for those involved in the family justice system. And again, I think those questions have been broadened out, and we did this through our work on women's repeat involvement in the family justice system, but also colleagues have talked about the kind of iatrogenic effect on kin networks and on communities of this form of potential social harm. So there are broader questions over and above the kind of permanency outcome questions that have gathered pace and are now really at the heart of family justice research. Just signpost this for if you want to do some further reading on open justice. Judith Resnick, who's at Yale, is great. And what she talks about is the contribution of public institutions in democratic life. And she talks about the public sphere. And there are kind of 2 parts to her argument. So one, she's saying think about public institutions much more broadly in terms of their contribution to to democratic life. And then in that context, when we talk about questions of legitimacy, of what we know, the justice must be seen to be valid, if you like, then there is an issue about an important role for the public in having access to these institutions and the institutions being open to legal and political scrutiny. Okay, so I hope you followed me on that first part. So I'm going to say, where are we now? So the family justice system, the president of the family division, who's at the head of the family justice system, has been pretty active in his term in relation to these questions. And in fact, in 2021, he initiated a transparency review. In 2023 to 25, he initiated a pilot program. And the way in which the justice system has responded so far is really with a focus on media access and legal bloggers, and also the issue of anonymised judgments. So progress has been made to address these legitimacy questions through the transparency review, and I can give you a link to that if you like. So we're moving as a system towards greater openness. However, now turning to the contribution of research, what I would say is that it's great to have some reporting at the level of the individual case, carefully done with the rights of children in mind. But I think that when we look at individual cases, we have no idea to what extent they represent the system as a whole. Are they, outliers? Are they highly anomalous? What actually can we draw about these issues at a wider level? And so that's where we really need to think more broadly. What I'd say about transparency in the debate where we are as a nation, or indeed UK-wide, I would say that media reporting has tended to dominate debates about transparency, with some more limited but welcome movement in the direction of recognising the need for research evidence of all types, but particularly large-scale population evidence. Okay, so if you want me to signpost the transparency review and the implementation group, I could do that, or you may already know about it. Okay, so just moving on then. So given this particular, very, very particular context of family justice, a highly contested domain where some of the most fundamental constitutional questions are at stake, what are the implications for researchers? So what I would say is that we need to be sure that our research questions reflect this broader set of issues. So we do need to address questions of outcomes in the short and longer term, and the ReCentre has been very good at this. We do need to address questions of service organisation and effectiveness, value for money, use of the public purse. But in addition, we need to address broader legitimacy concerns. And for researchers like yourselves and my group, we need to be really aware that our research will be heard, understood, and responded to in the context of these broader concerns. And this is sort of one of the first things I learned really when I was moved into doing family justice research and doing some work that was, quite high profile, was that I was going to get so many different groups trying to influence or lobby or criticize or maneuver me in one direction. And I think if you're aware and anticipate this, you can think about your response and where you want to locate yourself, which I think is a kind of position, it's a sort of subjective position. Am I positioning myself in a hard line in relation to this system, or am I going to or do I want to be inside the tent? Or do I want to really only do highly collaborative research that stays within the parameters of a kind of comfort zone, if you like, of frontline professionals? Am I going to align myself much more with lived experience? These are sort of decisions that you have to think about, and they're quite consequential then in terms of your future career. Okay, so just building on that point, I think the other thing I would say is that I started out as a qualitative researcher, then I moved into having a team with a mixed set of skills, and actually then developing quite a bit of hybrid knowledge myself in relation to quantitative research. When I did my PhD, I never thought I'd go in this direction. But what I realised over time is that if you want to address robustly this broad range of questions, it's absolutely essential to have in-depth, rich insights, do collaborative participatory research with frontline professionals, and really importantly, those receiving, using services, user voice. But one of the issues for the family justice system, which I've talked about quite a lot in a paper that I referenced at the end, is the recent history of family justice research is that it's largely qualitative. I think the work that a number of groups have been doing at UCL, at Lancaster, at Oxford, are trying to shift that balance a bit, but we still have an awful long way to go in terms of really using the value of admin data and really unlocking the potential of quantitative research in this space. So I would say we need to rebalance, and we need to enable greater supply of system-wide and population scale insights. So if I just give you an example here, say about the issue of certain populations feeling included or excluded, or trustful or mistrustful, benefiting from, not benefiting from the family justice system. You know, the qualitative question is really important. Why do individuals or communities mistrust services? But in order to develop a robust understanding of this, we also need to know which and are certain communities systematically disengaged or excluded. Okay, so that gives you a much more powerful set of answers than either side of this coin. Okay, so I think, just to kind of elaborate on this little point again, that qualitative evidence can really highlight negative or positive court experiences, but without system-wide data, we don't know how common these are. We don't know to what extent we can generalize. I think we should be really cautious about very small scale qualitative studies. I think they're fantastic for concept building. But if you've only interviewed 5 people in a particular area, what actually can we say about the system in a broader sense, or about a population in a broader sense? And I think sometimes we're a bit sloppy with inference from qualitative research in that sense. So I think the value of admin data, population scale evidence, is anchoring these decisions in representativeness, as well as questions of salience, or not just salience for particular experience or populations. Okay, so I've always favoured doing administrative data research wherever possible alongside quantitative research to get that rounded, robust and really rigorous picture and depth and breadth of what's going on. So now I'm going to talk to you about the contribution of admin data research. So I'm at 24 minutes past, so I probably do need another 15 minutes or so, Ian. So, okay, so the value of admin data. Okay, so the ADR UK is doing a phenomenal job unlocking these data sets. If you listen to the recordings from our ADR UK Community Catalyst, there's loads of recordings now that are really interesting, where people are also talking about how else can I get my hands on system level and population scale data. But the value of admin data is it is population scale, is system wide, and it's longitudinal. And obviously the longitudinal value increases year on year. We can construct relationships, we can construct households and communities, and we can do this over time. We can do this generationally. It can be multi-jurisdictional as well, so we can do UK wide. There's a huge potential. So I'm a big fan of ADR UK and where we are trying to go, although we have quite a long way still to go. We can also, with this data, ask and answer those broader legitimacy questions and uncover new ones. So I think admin data is not just a sort of narrow technical data resource, I think there's potential to really address that full range of system-wide questions I posed at the start of this talk. Okay, so thanks to Notebook LM for this little diagram. Here we go with linking data sets. So I know that Lucy Griffiths at the Sale Data Bank will talk to you a lot about linking data next week, and Bashar will give you a worked example from our study. But I mean, where we are now in terms of admin data is we're really trying to link data across these different systems. And I think that's where we really start to understand what's happening, what's going on. Why do people come into systems? What's their experience? But also understanding questions like, what is the experience of the user who's caught up in these different services? So recently, the Lancaster Swansea Catalyst Group did a consultation with senior colleagues throughout the system and advocacy organisations, and their biggest complaint was, we don't know much about what's happening about user experience that is beyond our particular system. So, for example, how is a family affected by GP waiting lists for mental health treatment in the context of community poverty and social care provision? You know, they wanted to know those questions, and it is through linking those questions that we get to that bigger picture. So that's where we're at now in terms of where we're trying to go. And so obviously, we're still kind of, you know, in the infancy and sort of in the weeds a bit with some of this, particularly around governance. And I'm sure Bashar will talk to you more about that in seminar 3. Okay, so third part of my talk, best practice in the use of administrative data. So again, I'm going to talk generally. I'm sure Lucy and Bashar will build on this, but first one is that to use interdisciplinary data well, you need interdisciplinary expertise. So to use admin data well, you need interdisciplinary expertise. Very difficult to do effective research if you don't have substantive knowledge of the topic together with higher level data engineering, data science, and quantitative expertise. You know, you need all of that. And sometimes in terms of substantive expertise, you might need law and you might need policy, you might need health. So it's done best in teams, although it can be done very well with through fellowships that are sufficiently scaffolded and mentored. The second point, I think is really important, this is theoretically informed. So one of the things that I think is problematic is people just getting hold of a data set and then just having a go with it and not understanding the context and not understanding the research that's gone before. So asking questions that don't make sense, giving answers that don't make sense, failing to, and we can go further, we can say failing to locate answers in their broader social, political and economic context. So I'm very much in favour of theoretically informed research in terms of social theory, as well as in terms of prior research. We need very close relationships with data owners. So data owners are not there just to give out data. They understand the data. I'm going to say more on the next slide about that, but you need to be able to collaborate closely with them. Collaboration with professional colleagues and individuals' lived experience is absolutely central. This is your pathway to understanding, your pathway to impact. You know, you sense you can't really do good research without having that ongoing dialogue. And then finally, combination of data sources, including qualitative, because when you start opening up questions with admin data, you will then move into opening up qualitative questions and vice versa. Okay, so just another little slide courtesy of the AI tool Notebook LM as well. So data providers are essential gatekeepers and collaborative partners. So that's the most important thing. They're not just there to give you data. It's really important, if you can, to strive for active collaboration. So data owners are actively shaping the data, and they provide the vital context about how this data has been captured, coded and categorized, and changes to this over time. I'm going to signpost a paper to you at the end where our team wrote about this, but there is kind of coding on the fly. There are changes to systems that are not always very well documented, geographic boundaries, categorizations over time. And it's important for you to capture those and understand them. And some of that's done by careful dialogue and understanding of this operational context of data provision. The other really important point is if you're doing complex linked studies, there's a massive governance challenge, and without those relationships, it's almost impossible to get to approvals. Okay. So I want to conclude the talk with an example from our Born into Care research series. So this is a research series originally funded by the Nuffield Foundation and the Australian Research Council, and published by the Nuffield Family Justice Observatory. And the observatory is also built on this by doing some important updates and commissioning further studies adjacent to the original research, creating a really nice portfolio of studies. So with this, we were interested, and it came out of another study on a lot of concern about babies in care proceedings and the extent to which care proceedings were being issued at the birth of the baby. So we provided the first statistical profiling of care proceedings at birth, which basically challenged any notion that people have that this was a rare event, was challenged by this. And we reported that actually, in terms of infant cases, a high proportion of infant cases were issued within 4 weeks of birth, probably around half, and about a third issued at birth. And we then having raised this question, began to address those other legitimacy questions. So we were then, getting people speaking to us, dialogue with us from all sorts of advocacy organisations. So we then began to ask the questions about, if this is far from a rare occurrence, what are the ethical, legal and procedural questions for these mothers who are experiencing care proceedings in the immediate postpartum period. So if you like, this kind of combination of outputs was creating a sort of distinct field of inquiry nationally and internationally. The success of this programme has been very successful in changing frontline practice, both in this country and in Australia, and influenced practice in New Zealand. And we've been combining robust longitudinal linked data analysis of parents and infants in care proceedings with in-depth collaborative analysis of frontline practice. So it's kind of, again, that sort of holistic attempt to look at things from a number of angles, but being very clear what that kind of population scale or big picture is. A key feature of the programme is what I call the redistribution of authority and voice, is in sustained long-term relationship with mothers who've been involved in successive studies with us. Okay, so just to give you one example of work, this work's just been updated by the Nuffield Family Justice Observatory. We published the original study in 2021. It's a really useful update by Charlotte Edney and Mary Ryan. And what we did was we counted the number of court hearings that were held on the same day that the parents or a mother was issued with care proceedings. So a mother in the immediate postnatal period who within hours or possibly days of birth was receiving notice she needed to appear in court on the same day. And it was something that had, been raised with us from a number of advocacy organisations, highly unhappy, disgruntled parents. So we produced this very simple chart, and here it is. So if you look at the Northeast, you can see that about 50% of infant cases, between 45-50% of infant cases, were being issued and the court first hearing held on the same day. And we compared that to London. So we've got the Northeast here, and we've got London next to it, where you have less than 10% cases. And obviously, it's this kind of inconsistency of practice from one place to another, which raises those really important questions of due process, substantive justice, but also, just a sort of fundamental questions about whether these liberal legal systems, which purport to an even-handed approach to cases, are indeed even-handed. When we published this, we got quite a lot of trying to find the right word, I think pushback initially from the judiciary to say, whoa, what's this, and a lot of concern about us publishing this data. But obviously, as researchers, we're here to publish data objectively, and to then look at why that's happening, to work collaboratively to understand next steps. In this case, sort of when the dust had sort of settled a bit on this first statistical release back in 2021, and other members of our group engaged in quite in-depth collaborative research around these issues, here we are now in 2026, where the judiciary has introduced a draft new baby protocol to be implemented across the family courts to reduce the number of same-day hearings. So I've always been really interested in a kind of end-to-end process of we do the research, we communicate research, and then we try to work with organisations on change. So myself and colleagues from the observatory joined this short notice applications group and then we also offered in knowledge to aid the judges to develop this protocol that aimed to reduce the problem that we just illustrated on the previous slide. You can see this is an update by the observatory in 2025. The first release was in 2024. So you can see sometimes how long it can take to make changes. But I think this is a really good example of that end-to-end process of uncovering an issue, working with people to understand the issue, and then working on a solution. And obviously we could go further than this protocol, but this is a great development on the part led by the judiciary. It's their protocol. Okay, so I think I've got about 2 minutes to go. So I just wanted to say, final plug, is that we've got a new book coming out which captures the whole captures a number of angles on care proceedings at birth from Canada, the US, New Zealand, Australia, and Europe, UK. And we've got a book launch on the 10th of June. You're welcome to attend. It's online. And we are just publishing the event sign up on our Centre for Child and Family Justice Research link there. But if you want to join that, you get a discount on the book, and we'd be delighted to see you there. But what we do with this book is we draw together contributors from across the globe. We set out our agenda in quite an extended introduction. We then bring together the international research evidence, and then we sort of synthesize that into a slightly more radical transformation agenda that has been currently set out for this space. And we've brought together sort of feminist theory, post-colonial thought, and other kind of critical perspectives to ensure that we've got a really nice tight weave between a kind of theoretical couching of this transformation agenda alongside some quite practical suggestions for change. And the whole book was steered by an organisation called Her Circle Up to Women's Advocacy Organisation in the Northeast. Okay, so I think that I've got a couple of references here. So there's a broad paper here about scaling up research, covers some of the points that I'm making. There's 2 examples here of the work on infants in urgent care proceedings. And then I've also signposted some of Judith Resnick's work for you, but she's obviously done a lot more work than that. And also this work from Tyler, which is quite interesting on procedural justice. I just want to go back to this and just say I'm also grateful to Rees colleagues, Harriet Ward and Bashar, for contributing to this book as well. And I think we're going to do some kind of combined news release with Rees. Okay, so that's me done. Thank you.
Thank you so much, Karen. That was really interesting, and I'm sure there's got lots of questions going around the room. A lot of people here that you mentioned. Harriet's now in front of me as well, and Neil's joined us as well.
Right.
In the corner, so plenty of time for questions. So please indicate. There's quite a lot of people in the room. I'm sure you can see everyone can, but there's quite a large gathering here. But there's also a lot of people online. So if you put your hand up if you like to session online, or colleagues, just put your hand up. Helen.
Teresa.
Teresa, okay. So Teresa.
That's a great start.
Yeah. There's a question there. So I'll read it out to you, Karen, to save you. So just thank you for your presentation and your team's work, but the continuing impact you've been having. Just wondered your thoughts on opportunities for barriers to use more anonymised judgments for research, and to what extent you think judiciary yet see producing these as key to their role to address the current issue that production and publication of these is so selective.
Yeah, so I think we do, as researchers, we do need to be a bit careful, because we know that certain judges anonymise and certain judges don't. So it's a very uneven picture. I think that certain judgments get published because they're particularly contentious. I think what we can learn from the judgments is the judge's response and the precedent that this sets for other cases. We can learn quite a bit about judicial thinking, but I think it is a problem that I think it's great that the family justice system takes seriously the issue of transparency and all of those legitimacy concerns that I set out. I don't think that media reporting, legal bloggers, and publishing judgments is enough of a solution. It's useful, but it needs to be complemented by really robust, more system-wide population scale data, because inevitably those are highly selective cases. We also know that since the transparency report was published and changes to practice directions to allow legal bloggers and media to have some access to the courts, it's very, very few people who do that. So again, it's highly selective and therefore somewhat anecdotal. So I wouldn't say it's not useful. It's great that the judges invest in that, but so far it's been a sort of fairly manual process without exploiting the options for sort of more machine reading, and inevitably some judges like doing it and others don't. Okay, I hope that answers your question.
Thank you. I'm looking for closing in the room. There's quite a lot of questions on that, so I'll keep reading them to first see my answers. So,
okay.
Question from Pitt Sutton. So, thank you for your presentation. I wonder to what extent, if any, UN CRC acts as a moral and practical underpinning for change here.
So, obviously, the UNCRC does influence our courts, but we've kind of got a long way to go. I think in relation to the previous question, and I hope I'm sort of interpreting this question in the way that you want me to, but I think that if you look at a country like Norway, so in our book we have a chapter from Norway. Norway's been particularly responsive to judgments from the European Court and is more responsive to issues around the UNCRC. I'm not so sure in this country that we are even able to make sufficient changes. But certainly the European courts become highly contested in relation to Brexit, etc., and doesn't have the impact that it would have in relation to the European courts and the judgments that come out of that when you compare it to other countries. So in our book, the chapter from our Norwegian colleagues in the book is a really good read in relation to how there was a kind of direct example of really responsive system-wide change. It was around questions of child reunification.
Thank you. So another question from Lauren Treisman. So I was wondering what ongoing research questions are currently being addressed and whether there are key data points that are currently missing in order to address these. The Domestic Abuse Commissioner at MOJ often talk about lack of data to adequately assess outcomes from the court long term, for example, others and what can be done to address these gaps.
Okay, thank you for the question, Lauren. So domestic abuse, massive gap. It's one of the most prevalent issues in the family justice system in terms of child removal, but we're not very good at all. A number of the data sets that have been made available through ADR UK, it's something we've raised with ADR UK, don't give you enough about domestic abuse. I don't know if Ludovine is in the audience, but I mean, Ludovine, who's based at Rees, did do some work trying to get to this question in relation to the family justice system, but there's an awful long way to go. It's a massive blind spot. But obviously, if one of the studies that Bashar's doing with Judith Harwin, just about to complete, I think, Bashar, isn't it? Judith's working on this now, where they've linked police national computer data to family justice data in relation to a subset of cases, is one way to go, where you try to create a representative cohort, and then you try to work with MOJ, etc., to link data on a sort of bespoke basis. Because I think at the moment the ADR UK datasets don't give enough access. One of the projects that Bashar and I are working on is the Child Outcomes for Mothers Facing Trial study, Comfort, where we're linking mothers' criminal records to family court records for the first time. Just finally had sign off on that after a year of going through governance. And I guess, the opportunity, we're hoping that by building that sort of population scale new national data asset, that we might then look to bring in police national computer data to that data set. Would need another grant, it would need more work, but you're absolutely hitting on a major blind spot in relation to the family justice system. Also in relation to crime, because from other studies we know that women involved in crime have often typically been victims of domestic abuse beforehand. So yeah, I hope that answers your question.
Thank you. And question from Judy Seppert, also thanks you for your major presentation. Judy said this is a very basic question, but actually there was a lot of this question. So she welcomed your point that we need more population system-wide evidence. How do you address the challenge from media coverage of single high-profile cases that have apparently gone wrong?
Okay, so really good question, Jude. So I think it is for the judiciary to respond to single case failures. They have to do that. So constitutionally, they're bound to do that. And they need to obviously what they typically do is they'll issue guidance, and the guidance from the higher courts is binding on the lower courts. So that's where precedent is really useful, because it's the law in a sense is sort of judge made, and it's not ineffective to publish high court cases and to set out what should change, and for the lower courts to learn from that and then to cite those cases. So I guess that's how rank, hierarchy, precedent, and, if you like, recompense works. So a single case should benefit other similar cases. However, the question still is, to what extent does that single case reflect a wider problem? Something that I've been trying to argue, Judy, about care proceedings in the immediate postpartum period is that this is an issue not just of an individual case, which has been highlighted at the case level, but it's an issue of systemic gender inequality in the justice system and a failure to recognise the embodied nature of care proceedings for women in the postpartum period. And it's getting to that broader system challenge, which is hard to do with a single case. So a single case can be quite effective in terms of procedural change, even in relation to the substantive justice of outcomes. But I think in terms of broader system level understanding and change, no. Other people might think differently. In relation to the sort of, the sometimes really unhelpful sort of salacious reporting, we've been probably some of our earlier media reporting we might think was unhelpful looking back, mother with 17 babies removed. That there's a challenge, isn't there, around responsibly putting things in the public eye and working with journalists to do that, and throwing a hand grenade in that just creates a lot of mess. Nobody benefits from it. I hope that answers the question, Judy.
Thank you. Colleagues in the room. Ludovine is here, by the way.
Hi, Ludovine.
Hi, Darren.
Hi.
I've got something I'd like to.
Hannah?
Hi, Karen.
Hi.
I wondered if you'd like to say something more about the sort of the other activities that have surrounded this work. So the work that Claire Mason led on the guidelines study, where we're talking about the changes to the family justice system as a result of discovering the numbers of care proceedings at birth. But that study also discovered appalling treatment of these young women throughout the period of entry to hospital, birth and so on, and what impact that has had.
Yeah, that's right. So I think that, you're kind of absolutely speaking to the same agenda as me here, Harriet, that that the admin data answers certain questions, but it doesn't answer them sufficiently in relation to user experience, in particular. And the work that Claire did to develop the Nuffield guidelines has been extremely transformative in relation to frontline practice, the kind of collaborative approach that she took. Then your work on that, Harriet, as well, has been immensely valuable in contributing to that portfolio of studies that have really affected change on so many levels for mothers and children in the family justice system. Does that answer your question, Harriet?
Well, I just wondered whether other people who weren't familiar with this work would be interested in knowing how it has an impact not only on the family justice system, but also on health professionals, social work, and so on and so forth. And you're in a much better position than I am to speak about this.
No, thanks for that. Thanks for that helpful prompt, Harriet. So for those of you who are not aware of the Nuffield Family Justice Guidelines, they were developed. The beauty of the study was the deep collaborative engagement with local authorities in England and Wales, which then provided a kind of, a living site, if you like, for change. So there was a kind of, not a full design, but a collaborative uncovering and a shared consensus around what the issues were. So we did the kind of like, how infant care proceedings are not rare, followed by a kind of deep dive into the practice of what was going on, and then followed by the translation into the guidelines, and then followed by local authorities buying into those. And I think the other interesting thing about this kind of end-to-end process is, you then have the DFE buying into this, health services, you're saying, Harriet, cutting across to midwifery, and also birth companions developing a charter for the first 1001 days. So you get this kind of cascading impact where, you know, you kick something off, you kind of really deepen understanding, and then others pick up and run with aspects of your findings as well. So the cumulative impact is much greater than it would have been on the basis of our team alone.
5. Yeah, I've just got a brief question, which is something I've been trying to figure out for a number of years. Why do you think it's gone so wrong? You know, in social education, we spend lots of time teaching social workers about anti-oppressive practice, how important it is to be working in a just way. And why do you think it's gone so wrong? And is there anything more that can be done to improve it?
Yeah, really good question, Clive. And nice to meet you. Sorry to meet you in person today, but never mind, next time. So basically, I think in terms of the judiciary, so when we've worked with judges, and those of you who've worked with judges, Teresa, I know, is on the call, and Ellie here, and Harriet, Bashar, you know, judges are incredibly fair-minded people. They want to see justice done, absolutely, 100%. And they wouldn't have gone down a kind of family court welfare route if they weren't, you know, incredibly ethically committed to this field. But I mean, they have extremely poor intelligence about what's happening. And then as the pressures on the system have increased, and, you know, the Family Justice Review in 2011 basically ushered in a much, much more impatient, faster, streamlined system where, you know, essentially you had to get your head down and get on with the job, because you're going to be sort of pilloried over missing the deadlines. So you've got a system where I suppose there isn't the time, the space to set back. Judiciary do some of that. They're doing some really good work at the moment in the private law space, with Nuffield Observatory, around child's voice. But, you know, in general, it's like the train. You know, the train. It's a runaway train, the system, and there isn't the time to stand back and take stock. Clive, have you read a book called Borderline Welfare by Andrew Cooper? I'd really recommend reading it. It's a really accessible read, but it's called Fear and the Fear of Feeling. And it's somebody, I'm trying to think of, it's Cooper and Lusada. It's quite a few years old, but it's really worth reading because it captures what happens in these big bureaucracies when they're, you know, just basically losing the will to live through their bureaucratic strain and the overload and pressures of work, and the kind of emotional shutdown that occurs as a consequence of that. But it's a great book for capturing that. What looks like intransigence, but isn't really intransigence. It's more about just not having the energy and the time space to look up and make changes to the system. In social work, I mean, we train social workers, they go into practice and then they're desperate to leave. Just the state of public services. And then they would say, can we come back and work with you in the university? But I think we have to, Clive, hold on to our slightly more utopian ideals whilst preparing people for the realities of the front line.
Thank you so much, Karen. I think we're coming to the end of time. I'd also like to thank you for sharing all those insights, but also beginning this series off in such a tricky way. There's lots of questions, and maybe I'll ask you probably some other point. That I have an interest in that regional variation, how much judges can influence that, because I have my wife has worked in frontline social work for a long time, so and CAPCAS.
Yes.
Some insight into that world. So thank you, Karen, and just give appreciation to Karen again.
Thank you.
And just so that mentioned, really good to have such a great turnout both in the room and online. The next one the next webinar in this series is Understanding Children and Families Through Linked Data, Opportunities and Evidence. And we're very pleased to be joined by Professor Lucy Griffiths from Swansea, who's co-director of ADR Wales, and academic research lead, co-lead of ADR Community Catalyst, Children at Risk of Poor Outcomes. So it'll be a really good follow-up to Karen's work. And then following that, we have once of Lancaster and now of us. So thank you for the transfer. Dr. Bashar Al-Amrou is a senior research fellow here at Rees, and he's going to be talking about sort of work obviously he's done with Karen and Lancaster, children and family outcomes in the family and criminal justice systems, insights from the administrative data. So hope to see everyone at those events as well, and thanks again, Karen, and really good to see you, and hope to see you in person next time.
Yeah, lovely. Thank you very much. Thank you.